Hello all, in this video we shall be discussing about patent. Basically, when a person invents a new product or finds out a new way of producing a product, that person is granted an exclusive right for that invention, and that is known as patent. So patent is basically a form of preservation of intellectual property where a person discovers a new way of doing something or offers a new technical solution to a problem. That person is given an exclusive right in order to preserve that intellectual property, and that is known as patent. And to get a patent, it is necessary that the technical information about the invention be disclosed to the public in a patent application. Now, by rewarding patents, what is the idea behind giving patents? The advantage of giving patents for new inventions is that it will again further encourage innovations and creativity in every field. So that is the basic idea behind giving patents for new inventions and innovations. With respect to the Indian patent law, the Indian patent law grants a 20-year patent monopoly to an inventor. So basically, when a person gets his or her invention patented, it means that only that person will have the exclusive rights of producing that product, and nobody else can produce that product for a period of 20 years. So the monopoly of production is given for a period of 20 years. Now, in exchange for such monopoly, because when a person gets the product or invention patented, in exchange for such monopoly granted, the Indian patent law states that, a duty on the patentee. Patentee is basically the person who is getting his invention patented. So, the patentee has to work the invention in India commercially, basically has to produce the product or make use of the production process that the person has invented and produce products on a large scale for commercial purpose, so that that particular invention's benefit reaches the public. So the Indian patent law grants a 20-year patent monopoly to the inventor, and in exchange of such monopoly, it is necessary that the patentee produce the product or make use of the process that he has invented to produce products on a large scale, basically commercially, to ensure that its benefits reach every citizen. The Indian patent law has a very unique provision which is usually not found in the patent provisions of other countries, and accordingly section 146 subsection 2 of the Indian Patent Act states that every patentee and licensee has to submit to the patent office an annual statement explaining the extent to which they have worked the invention in India. So basically, when a person has invented something and that person goes to get that invention patented, that person is granted a monopoly for a period of 20 years, right? And in exchange of the monopoly, the government says that you have to produce this product on a commercial scale so that the benefit reaches the citizens. And therefore, basically the government is cross-checking. It is required that the patentee and the licensee submit to the patent office an annual report of actually how much the production process has been undertaken, actually how much has the innovation been used in practical terms. So this will help the patent office, potential competitors and others to determine whether the patentee has worked the invention in India and made it sufficiently available to the public at reasonable prices. And if the patentee or the licensee fails to comply to this, then that could trigger compulsory licensing or even the revocation of the patent under the Patents Act 1970. The Patents Act 1970 was recently amended in 2020, and the amendment has changed the format of a statement which requires the patentees and licensees to annually submit to the patent office the extent to which they have commercially worked or made the patented inventions available to the public in the country. So that was the provision of the Patents Act of 1970, wherein it is is mandatory on the part of the patentees and licensees to annually submit to the patent office the extent to which they have commercially worked the patented invention. But the Patent Amendment Rule of 2020 has amended the format of the statement, and this amendment has significantly weakened the disclosure format, and this could actually hamper the effectiveness of India's compulsory licensing regime, which depends on full disclosure of patent working information. This could also in turn hinder access to vital inventions, including life-saving medicines, thereby impacting public health. And because of the fact that this amendment can hinder access to vital inventions and also impact public health and other aspects of public life, there has been significant pressure from multinational corporations and the United States government to do away with this requirement. We now move on to discuss the model question with respect to the topic we have been discussing so far. The model question for your practice is: the patents not only encourage innovation but also ensure that the inventions are worked in India and are made available to the public in sufficient quantity at reasonable prices. Comment in light of the newly published Patent Amendment Rules 2020. I hope you found this session valuable. If you liked the session, kindly do not forget to like, share, comment and subscribe to our channel. Thank you.